Revenge is a silver blade, silent and sharp, waiting for the perfect moment to deliver the final, crushing blow. Follow the high-stakes journey of a soul who navigated the path of betrayal to find their ultimate redemption. Subscribe now and see how the final debt is paid in full.
I didn't say a word when my daughter told me I was being moved out of my own home. I just sat in my recliner, the one Margaret bought me for my 60th birthday, and watched her husband carry my bookshelves into the garage like they were yard sale furniture. My son-in-law didn't look at me once. He had the practiced efficiency of a man who had rehearsed this moment many times in his head. My daughter stood in the doorway with her arms crossed and her eyes somewhere above my left shoulder. "It's just temporary, Dad," she said. "Until we get you properly settled." Properly settled. That's what she called it. I nodded slowly and said nothing. That's something people misread about me. They see a quiet 68-year-old man in reading glasses and a cardigan, and they assume the quiet means helpless. They assume it means I don't understand what's happening. I understood everything. I just needed a few more days. Let me start from the beginning, because none of this makes sense without it. My name is Robert Calloway. For most of my adult life, people called me Judge Calloway. For 22 years, I sat on the federal bench in Nashville, Tennessee. Before that, I spent 8 years as an assistant U.S. attorney. And before that, I clerked for a man named Harold Fitch on the Sixth Circuit, a judge so sharp and so patient that he could dismantle a fraudulent argument the way a watchmaker takes apart a broken clock quietly, methodically, with total certainty about where each piece belonged. Harold taught me that the most dangerous thing you can do in any proceeding is reveal your hand early. "Wait," he used to say. "Let them build the case against themselves. People who believe they're winning always overreach. And when they overreach, that's when you move." I retired 4 years ago when Margaret got sick. Pancreatic cancer. We had 9 months from diagnosis to the day I held her hand in the hospice room, and she told me to stop apologizing for things that weren't my fault. She died on a Tuesday in October, and the maple tree outside our bedroom window dropped every one of its leaves that same week, like it was keeping her company on the way out. My daughter Claire had been living in Atlanta with her husband Derek for 6 years by then. Derek sold commercial real estate and wore suits that were slightly too expensive for his actual income. He had a firm handshake and very white teeth, and the particular confidence of a man who had never once been wrong about himself, at least in his own estimation. Claire called me 3 weeks after the funeral. "You shouldn't be alone in that big house, Dad," she said. "We've been talking about it. Derek thinks it makes the most sense for us to come back to Nashville. You need family around." I told her she didn't have to do that. She said she wanted to. That should have been my first warning. Claire had not wanted to visit Nashville for the holidays in 3 years running. She had not wanted to be present for her mother's final weeks until Margaret specifically asked for her. She had not wanted, as far as I could tell, anything that required significant inconvenience on her part. But she wanted this. They moved in on a Saturday in January, 2 months after Margaret's funeral. I gave them the master suite. I took the smaller room at the end of the hall, the one with the window that looks out over the backyard and Margaret's rose garden, which I had been carefully tending since October, because it seemed important to keep alive. The first month was fine. Claire cooked sometimes, and it reminded me of when she was young, before Derek, before Atlanta, before she became someone I recognized mostly from photographs. Derek was polite in the distracted way of a man counting ceiling tiles at a function he didn't want to attend. I told myself it was an adjustment period. I told myself this was what family looked like after loss. Then the adjustment period ended, and the real arrangement began. It started small, the way these things always do. Could I not watch television in the living room after 9 because Derek had early calls? Could I use the side entrance when I came in from my morning walks because mud tracked across the hardwood? Could I possibly eat dinner earlier because their schedule had shifted? I said yes to all of it. I was a federal judge for 22 years. I have heard every variety of escalation strategy ever devised. I know exactly how a sequence of small concessions is used to normalize a fundamental transfer of power. I watched it happen, and I said yes anyway because Claire was my daughter and I had just buried her mother. And I thought, foolishly, that I was reading too much into it. Then I found the paperwork. Derek had been using my study since they moved in. My study, with my books and my desk and the framed copy of my bar admission certificate that Margaret had hung there 30 years ago. He'd pushed my things to one side and set up his laptop and his files in his ergonomic chair, and I had not made an issue of it. One Thursday in March, Derek was out showing properties and Claire had gone to a yoga class. I went into the study to retrieve a book I'd left on the shelf, and the file folder was sitting right there on top of my desk, not hidden, not locked away, just sitting there, because Derek was the kind of man who never imagined anyone would look. Inside the folder was a copy of my will, not the will my attorney Gerald Marsh had drawn up for me and Margaret 12 years ago, updated after her death to reflect changed circumstances. A different will. Same format, same general language, same notarial seal at the bottom, but the signatures were wrong. Margaret's signature was there, dated 3 years before she died, on a document that referenced assets and accounts that hadn't existed 3 years ago, and my signature, which I had never made on this document. I stood at that desk for a long time. The old instincts came back fast, the way they always do when you've spent enough years recognizing a fraud. I looked at the distribution. Under this version of the will, the house and the majority of my assets passed directly to Claire, bypassing the trust structure I had set up for my grandchildren and the charitable distributions Margaret and I had agreed on together. There was also a power of attorney document again, my signature, again not mine, giving Claire full authority over my finances and healthcare decisions. I photographed everything with my phone. Put the folder back exactly as I found it, at the same angle, on the same corner of the desk. Then I went to the kitchen and made a pot of coffee and sat at the table where Margaret and I had eaten breakfast for 31 years, and I thought. I did not call Gerald immediately. I did not call my son from my first marriage, Thomas, who lives in Portland and who I had been meaning to call for weeks. I did not call anyone, because Harold Fitch's voice was very clear in my head. Let them build the case against themselves. I needed to know how far along this was. The forged will was drafted. The power of attorney was drafted. But had anything been filed? Had Derek already spoken to someone? I needed the complete picture before I moved, because moving too early with incomplete information is how cases fall apart. I had watched it happen from the bench more times than I could count, so I waited. Over the next 2 weeks, I paid attention in a different way. I started noticing Derek's phone calls, not the words, just the pattern. He stepped outside for certain calls. He closed doors. He had 3 conversations with someone he called my guy at the firm that ended abruptly when I came within earshot. Claire started asking questions about my health with a frequency and a specificity that felt rehearsed. Had I seen a doctor recently? Did I ever get dizzy? Had I considered that maybe the house was too much for one person to maintain? One evening at dinner, she slid a brochure across the table to me. Meadow Creek Estates. Senior living with dignity. Derek and I drove out to look at it last week, she said. It's really lovely, Dad. They have a wood shop and everything. You always talked about wanting to do more woodworking. I picked up the brochure. I looked at it for a moment. How much does it cost? I asked. Derek cleared his throat. Well, that's the thing. With the equity in the house and your investment accounts, you'd be completely comfortable. More than comfortable. My investment accounts. Of course we'd manage everything for you. Make sure all the bills were handled, nothing for you to worry about. He said it like he was offering me a gift. I set the brochure down. I'll think about it, I said, and I did think about it. I thought about it very carefully. 3 days later, I called Thomas in Portland. Thomas is 42, the son of my first marriage, an architect, sensible and private in the way of a man who grew up watching his father spend long hours reading case files. We had not been as close as I would have liked over the years. Distance does that, but Thomas has his mother's judgment, which is considerable, and when I explained what I had found, he was quiet for a long time. How do you want to handle it? He asked. I need a few things, I said. I need Gerald. I need someone from the State Bar Fraud Unit. I still know Frank DeLuca over there. And I need you to contact the financial institutions and find out if any of those documents have been submitted. And what do I do when I find out? Nothing yet. Just let me know. Thomas called back in 4 days. Derek had not yet filed anything with the courts, but he had made inquiries. He'd contacted a probate attorney in Brentwood, a man named Stern, who had apparently advised him that the documents needed some revision before they'd hold up to scrutiny. Stern had flagged the power of attorney language as insufficient for contesting existing estate documents. Derek was waiting for revised paperwork. I had a window. What happened next was not dramatic. There were no raised voices, no confrontation at the dinner table, no moment where I revealed what I knew. That's not how things work when you've spent a career in federal court. Real resolution is paperwork and procedure, and the application of very specific pressure at very specific points. I called Gerald Marsh that Tuesday and told him everything. Gerald has handled my legal affairs for 25 years and has the unshakable composure of a man who genuinely believes in the orderly functioning of legal systems. He was furious in the quiet, precise way of a man who takes document fraud personally. He contacted Frank DeLuca at the bar's fraud unit that same afternoon. 2 days after that, I called a man named Wallace Briggs. Wallace and I go back to my time as a federal prosecutor. He was a financial crimes investigator for the FBI's Nashville field office, and we worked 3 cases together in the late 1990s, 2 of which resulted in convictions that still hold up as examples of how asset fraud cases should be built. Wallace retired 7 years ago, and now consults for several large financial institutions on fraud prevention. He golfs on Tuesdays and Thursdays, and answers his phone on the first ring every other time. "Robert," he said, "it's been a while." "It has," I said. "I need your eyes on something." I explained the situation. Wallace asked 3 questions, all of them procedural and precise. Then he said, "Send me copies. Give me 48 hours. I sent him copies. In the meantime, I went on as normal. I ate dinner with Claire and Derek. I admired the brochure for Meadow Creek Estates when it came up again. I mentioned, mildly, that I'd been thinking about their suggestion. Derek visibly relaxed. Claire smiled at me with something that almost looked like relief. That look told me everything I needed to know about the timeline. They were close. They needed me cooperative and compliant for just a little longer. And I was giving them exactly what they needed to see. That was a Thursday. By Saturday, Derek had begun moving my bookshelves into the garage. I sat in my recliner and watched him do it. Claire stood in the doorway with her arms crossed and told me it was temporary, just until I got properly settled, and I nodded and said nothing. I was waiting for Monday. On Monday morning, Claire went to her yoga class at 9:30. Derek announced he had property showings and left at 9:15. I waited until his car had turned the corner at the end of the block. Then I called Gerald. "Is everyone in position?" I asked. "Everyone's in position," Gerald said. At 11 o'clock, Gerald arrived with a representative from the State Bar's fraud unit, a young woman named Patterson, who had the eyes of someone who had spent too many years looking at documents people wished she hadn't seen. At 11:15, Wallace arrived with a colleague from his firm and a packet of materials he had assembled over the past 4 days. At 11:30, my son Thomas arrived from Portland. He had flown in that morning and taken a cab from the airport and walked into my house carrying a bag and looking very much like a man who had been wanting to do something useful for several weeks. We sat in the living room, the one Derek had rearranged, and Gerald walked us through the legal sequence. The forged documents constituted fraud. The power of attorney was void on its face because it had been executed without my consent or knowledge. The will would not hold in any Tennessee probate court, particularly given that Gerald had the original, properly executed document with every signature and notarial certification in correct order. Wallace's materials were more pointed. He had traced Derek's financial activity over the past 18 months with the particular thoroughness of a man who has spent a career following money. Derek had significant personal debt, about $190,000, accumulated through failed real estate ventures in Atlanta, and one short-lived business with a partner who had since declared bankruptcy. He had been servicing minimum payments for 2 years. The plan, as far as Wallace could reconstruct it, was to establish the power of attorney, transition me to Meadow Creek Estates, liquidate the house and the investment accounts, pay the debt, and retain the remainder, clean, tidy, and nearly impossible to prove if the documents had been filed before anyone caught the forgery. What does he not know? Thomas asked. He doesn't know that Gerald has the original will in a secured location that has been on record at the county clerk's office since it was executed, Gerald said. He doesn't know that 2 of the institutions he contacted regarding the power of attorney notified us as soon as they received the inquiry. And he doesn't know, he added, looking at me with the particular satisfaction of a man who has been practicing estate law for 30 years, that your father spent 22 years on the federal bench and knows every person in this room personally. Patterson from the Bar Association looked up from her notes. We have enough to refer this for criminal prosecution. Forgery, fraud, exploitation of a vulnerable adult. He's not a vulnerable adult, Thomas said. That's the language of the statute, Patterson said. 65 and above. It's actually worse for them legally. She almost smiled. Derek came home at 2:15, walked through the front door, and stopped. The living room was occupied by people he did not recognize, and one person he did, which was me, sitting in my recliner with my reading glasses on, looking, I imagine, very much like the federal judge I had been for 22 years. What's going on? He looked at Claire, who had returned from yoga to find the house rearranged in a different way than she had left it. Claire looked at me. For the first time in months, she was reading the room correctly. You should sit down, I said. Both of you. Gerald explained the situation with the measured efficiency he brings to everything. He laid the forged documents on the coffee table next to the originals and walked through the discrepancies one by one. The way you'd present exhibits to a jury. Clearly, without drama, with the full weight of specificity. Derek's face went through several stages. Confusion first, then a brief and unconvincing attempt at indignation, then something that was not quite collapse, but was the nearest thing to it I had seen on a face that was accustomed to presenting confidence as a primary business tool. Claire was quiet throughout. She sat with her hands folded in her lap and did not look at Derek and did not look at me. And I recognized that posture because I had seen it in courtrooms. It was the posture of someone recalculating. When Gerald finished, Patterson set a card on the table and explained the referral process. Wallace's colleague outlined the financial restitution exposure. Thomas sat beside me and said nothing, because he had been raised to understand that silence in a room like this was more effective than anything he could add. Derek started talking. People always do. He said it wasn't what it looked like. He said he had been under pressure. He said the intent was always to protect me, protect my assets. He'd just gone about it the wrong way. He could explain everything. He just needed a chance to explain. I let him talk for about 90 seconds. Then I said, Derek. He stopped. I spent 2 decades listening to people explain why the evidence didn't mean what it clearly meant, I said. You are not going to be the first one who succeeded. The room was quiet. Here is what's going to happen, I said. Gerald is going to file the corrected estate documents this afternoon, which will formally invalidate anything you submitted or attempted to submit. Wallace's firm has already notified the relevant financial institutions, so any further attempts to access my accounts will be flagged immediately. Patterson is going to pursue the bar referral, which means Derek, your name and these documents will be part of a formal state record regardless of what else happens. Derek opened his mouth. I'm not finished, I said. You have 2 weeks to make other living arrangements. Your names will be removed from all utilities and accounts associated with this property. If there is any attempt to contact Gerald, Wallace, or any of the institutions involved for any purpose other than cooperation, the criminal referral will be fast-tracked rather than reviewed. Claire finally looked at me. Dad, I'm not finished, I said again. And my voice was the same voice I had used for 22 years on the bench. And she stopped. Claire, I said, and my voice changed. I know you were frightened. I know Derek told you this was the only way to manage things, that I was getting older and the house was too much, and it made sense for everyone if things were organized in advance. I know how he talks when he wants something. I've watched him for 6 years. She was very still. I also know that you signed the power of attorney, I said. Your signature is on those documents. Whether you understood what you were signing, I don't know. Gerald believes it doesn't matter legally. I paused. But it matters to me. And I want you to understand that it matters to me." Her eyes filled. She didn't speak. "You have 2 weeks," I said. "That's more than fair." They left the room. I heard them upstairs, heard the low, urgent conversation through the ceiling, heard the particular silences that come between two people who have just discovered they are not as unified as they thought. Thomas sat beside me and we didn't speak for a moment. "You could have called me sooner," he said finally. "I know. I would have come. I know that too." He looked at his hands. "Are you all right?" I thought about the question. The house was quiet around us the way it used to be quiet, which is a different quality of silence than the kind that had occupied it for the past several months. Through the back window I could see Margaret's rose garden, where the first spring growth was beginning to show along the canes. "I'm working on it," I said. Thomas stayed for the week. He helped me move my bookshelves back from the garage, and we ordered pizza 2 nights in a row and stayed up too late the way we had not done since he was in college. He has his mother's laugh, which I had forgotten, and it filled the rooms in a way that felt like something returning rather than something new. Gerald filed the corrected documents that Monday. The originals were formally recertified with the county clerk, and a notation was placed in the probate record that any future claims against the estate required additional verification given the documented fraud attempt. Patterson's referral moved through the bar at its own pace, which is to say slowly and inexorably, the way bureaucratic processes do when the paperwork is unambiguous. Derek and Claire were gone by the end of the second week. I don't know where they went first. Wallace told me, without elaboration, that Derek had been served with a civil complaint related to one of his Atlanta business arrangements, something that had been pending for over a year, and that apparently this situation had shaken loose. I told Wallace I hadn't asked about that. He said he knew. He just thought I should. Claire called me 6 weeks later from an area code I didn't recognize. She didn't explain herself or apologize directly, which I had not expected. She asked if I was managing the house all right. I told her I was. She asked if Thomas had gone back to Portland. I told her he had, but that he was coming back for Thanksgiving, and she was welcome if she chose to come without Derek. There was a long pause. "I don't know what that looks like," she said. "I don't either," I said. "But I know what it doesn't look like. It doesn't look like forged documents and Meadow Creek Estates brochures and someone else's hands on the deed to my house." Another pause. "I'm sorry, Dad," she said. It was brief and imperfect and probably not the full accounting she owed me, but it was real. I have been in enough rooms to know the difference between a statement offered for effect and one that costs something to say. "I know," I said. We talked for a few more minutes about nothing in particular, and then she said she needed to go, and I told her to take care of herself, and we hung up. I stood in the kitchen after that call, next to the window that faces the backyard. The rose garden was in good form. The climbing Don Juan on the east fence had put out its first flush of the season, the deep red blooms Margaret had specifically requested when we planted it 20 years ago. I had been keeping up with the pruning, not perfectly, but well enough. People ask me sometimes, neighbors and old colleagues who have heard pieces of what happened, whether I feel like I handled it correctly, whether I should have confronted Claire sooner, been more direct, given Derek the chance to correct course before things reached a formal proceeding. I understand the question. There's a version of this that looks like I let it go too far, that a father who truly wanted to reach his daughter would have sat down with her weeks earlier and had an honest conversation and tried to bridge whatever distance had opened between them. Maybe, but I had watched the evidence accumulate, and I had watched Claire watch Derek, and I knew that confronting them without the complete picture would have produced a denial and a scramble in documents filed in a hurry, and then we would have been in probate litigation for 2 years while a judge younger than my briefcase untangled the forgery. I had spent a career understanding that timing is not cruelty. Timing is the difference between a case that holds and one that falls apart at the seams. Harold Fitch used to say, "Never make your move until the record is complete." The record was not complete until Wallace called me on Sunday morning with the financial trail and Patterson confirmed the scope of the fraud statute. That was Monday's move, not Thursday's, not the week before. Harold also used to say that the outcome you're building toward should be the right outcome, not just the winning one. I didn't want Derek prosecuted. though he may yet face consequences from other directions that have nothing to do with me. I didn't want Claire estranged. I wanted my house, and my documents, and my life returned to the state they were in before someone decided that a grieving 68-year-old man reading in his recliner was an opportunity. I have that now. Most mornings I walk the neighborhood for 45 minutes, the same route I've walked for 15 years. The diner on the corner makes good coffee, and the owner, a man named Pete who came over from Thessaloniki in 1987, always has the booth by the window ready for me at 8 o'clock. I tip well and I don't cause trouble, and I listen to the conversations around me with the particular attention of a man who spent 2 decades professionally required to understand what people meant as opposed to what they said. I visit Margaret on Sundays. I tell her about the week. I told her about Thomas's visit, about the roses, about the phone call from Claire. I don't know what she would have thought about all of it, but I know she would have had opinions, specific and well-reasoned ones, and I miss those opinions every day. Last week I ran into an old colleague from the U.S. attorney's office at the farmer's market downtown. He shook my hand and asked how I was doing, and I told him I was doing well, and he looked at me the way people do when they're trying to figure out if that's the polite answer or the true one. "Really?" he said. "Really," I said, and I meant it. There's one thing I haven't resolved yet. The wood shop at Meadow Creek Estates, that part was actually not wrong. I have wanted a proper wood shop for 20 years, and there is a perfectly good section of my garage that Derek cleared out when he moved the bookshelves that I have been looking at with some intention. Thomas mentioned at Thanksgiving that he'd help me set it up if I got the tools in order. He's coming back in the spring. We made a plan. Margaret always said I should have built more things with my hands instead of sitting in judgment of what other people built. She wasn't wrong about that, or much else. I'm looking forward to finding out what I can make when I put my mind to it.